ile kazi yenu mzuri mnafanya, sisi hatukuje na tukasema alafu badala article 50.
I don't trust this system anymore. So that's what I want you to understand as much as possible. So what is this about the victims? How many victims are being told what judgment has been made and what happened to the offender? And does that really satisfy the victim? Do the members of the community know about it? So there's a very serious gap that we need to look at, that restorative justice comes to serve. So the crime usually is against the state.
What we can do outside court. We've learned about diversion, we've learned about plea bargaining, we've learned about mediation. These are all out of court. They may be court annexed, but in most cases you do them out of court. And then, now, we are looking at the instances where those initiatives, for one reason or the other, may not be working, such that this matter must now proceed to court. Are you seeing the timing? Yes. Had we started with this in the morning, you'll all be confused by now. You'll all be confused. But my lordship has taken you through in a very, very systematic manner. You get to know what you can do at the comfort of your hands. You sort out as many as possible at the police stations, in your offices, at the DPP, and all those other areas, including the advocacy. But now for those ones which are not capable of being settled, they come to court. When these matters now come to court, that's a
we are discussing here is what is hurting our people outside there. Number two, I want to say that as the Ethics and Anti-Corruption Commission, we are committed to this same cause, participating with other players to ensure that justice is delivered in time. Because justice delayed is just denied. And we are very lucky that we have a law, the supreme law of the land, the Constitution, which has provided other ways of ensuring that this is met. And that's where ADR comes in handy. As a commission, we also deal with all those three things. When there is a diversion, we work with the DPP and we use it as a means of ensuring there is justice. And more so, we are talking about justice which is done in good time. Number two, plea bargaining is usually spearheaded by the DPP, but we are players, as you saw in the presentation. The investigative agency is a very important player. For us, one of the most important ADR mechanism which is working for us is the issue of the civil matters. We have quite a number of civil matters in the courts. We have tried as a commission through the court system to recover quite a number of parcels of lands, quite a number of monies which are for people who are involved in criminal, not really criminal, but corruption-related enrichment, which is illicit, and we do recover. And this, in most cases, actually deals with land. It deals with the issues to deal with the. Nowadays, you have heard of people who have got certificates which are fake. It is a very common thing here. We translate that from the criminal. There is the criminal end, and there is also, since that time you were employed with a fake certificate, to date, we want to recover what you used, what you got, because it is a fraudulent acquisition of public property.
The accused person agreed to plead guilty or not to contest to some crimes for which he is charged. What for? Why? So that he gets some reduction in the severity of the charges that have been preferred, or to even have some of the counts or charges removed. Or, of course, for that person to enjoy some other benefits that may come along with his agreement to plead guilty to the charges that he's facing. So that is what plea bargaining is. And I will quickly tell you that that kind of negotiation will eventually result in a plea agreement. Let's go to the second page again. Well, we can share this slide, but if you allow me, because I said I want to take about 10 minutes, my lord. So we will have what we call then a plea agreement, which is also known as a plea deal. Okay? A plea agreement is a culmination of the plea bargain process. Once the prosecutor and an accused person get into a complete bargaining process, they record or come up with a plea agreement. Hiyo slide yetu kidogo na mimi hatuendi sambamba. So we don't need to talk about the history of this because it is anchored in law. What we are doing is already anchored in the provisions of the law, as you have seen. So, of course, that is what we are saying is the legislative framework, which is there. We all know. Yes. Now, here, let's just go to the other slide. Maybe before we go to the benefits, we can talk briefly about when, for example, now a plea agreement can be used. Now, in summary, this is when we all know, that is, or both sides, that the evidence is sufficient to warrant a conviction. That is key. The accused person being faced with the evidence will oftentimes know that the evidence is such that it's going to lead to a conviction. Now, what happens then? That's when the negotiations, of course, take place and a plea agreement is drawn. And of course, this is done voluntarily. It is done voluntarily without any coercion. Nobody is going to be coerced. And it is important perhaps at this point to say that who can initiate this? I think either party can initiate, either the accused person, the advocate, or us, because I think we try to do this oftentimes. We tell them, look, you have all the evidence. Don't you think that, you can't really escape? So we are willing to listen to you. If you are willing to plead guilty, then we can agree.
The police service controlling another protocol and then another organ of the Constitution. What do I mean? The moment the National Police Service, those countries which have succeeded, including the European and also the Americans, is that the moment you finalize with the investigation, you hand over all the protocols to the prosecution council. The Crown Prosecution Council, then the Inter-American, what they call the DOJ, and in terms of that. The moment you run this two parallel system, that's why the Constitution is actually very clear. This holding on of files, holding on for the witnesses is something the country must change if we are going to really live up with the Constitution. The second thing is, in other jurisdictions, there is no judiciary to pay witnesses. That's not the work of a judiciary, to pay witnesses, because that's not, they are outsourced. Witnesses is not within the province of the judiciary. It is the Crown Prosecution Council, like in the UK, they have created what you call a witness care. Some kind of unit within the prosecution. That witness care is the one task of the question, looking at the welfare. When are you coming? Are you available? When is your date? They're the ones who make that. So that the witness, if there are any reimbursements, payments, it is that witness care says, we have a vulnerable witness, we have an expert witness, we have a child witness. Those kind of protocols. The judiciary does not have the capacity to deliver the question of witnesses. That's an outsourced service. Because what happens? It is easier for the director of public prosecution Or now, if we still retain this hybrid system for the Inspector General to go to Parliament and see of this number of cases aligned up for the various courts, I want 500 million to pay witnesses. The question
19 to 57. We will not go into the details of how this Bill of Rights came into being, but they have a very lovely history from the international community, the Universal Declaration of Human Rights, running to regional instruments like the African Charter on Human Rights, coming all the way to Katiba. But we will not go. We will not deal with that because I don't want to tire you and I don't want to lose you. Is your neighbor showing any signs of?
That will just show how committed you people are to this particular cause. To me, I'm humbled that you made
access to justice is because they are key stakeholders in the system. Their absence definitely impacts. I'll give you a replica scenario. Like the matters before my court and the storage in the registry. If for one reason or another that file is not available to court, nothing will happen for that day. So equally, the absence of my file from the registry impacts negatively. But I beg to ask the question, in as much as I'm a panelist, does a single prosecutor know by number how many files are his or her docket for prosecution at any particular given time? And I hope, I know for judiciary, with the e-filing system, we are getting there. All matters assigned to me, I'll be able to any given time with the button, just a click of a button, know what I have. If that can be replicated at the ODPP, it will be much easier for them to follow through and know which files are missing out. Thank you.
Hearings normally exposes the weak link between the ODPP and the police, meaning probably that there is no proper communication. They don't get information in time as to which files are supposed to be availed before court. Secondly, police are exposed to several emergency duties that they do perform. And at times, when an emergency calls, you'll find that the officer handling a case may be sent somewhere without even given time to hand over the file. And if a proper record is not kept by the OCS or the OC crime, this may lead to non-production of police file before the court. So this calls for proper record keeping by the OC crimes and the OCSS to ensure that they monitor and keep a record of the movements of all files, and at any given time they should know the position of the police file. Thank you.
Because the DPP retains duplicate files, and it's because there are few files, so the number is manageable. But when it comes to the Chief Magistrate's Court, we don't have the duplicate files. That's why when it comes to mentions of hearing, most of the time, the police files are not available. But then we need to ask ourselves why these files are not availed on the date when they are required to. We realize that most of these files that do not have dates or which are not available is because they do not have dates indicated in the police file. And most of them arises from cases which they fall on a certain day, then for some reason the matters do not proceed or the courts do not sit, then we are told will be given dates by the court assistant. Now those dates being communicated to the police is a bit of a challenge. We have our challenges within the office when it comes to communication. So, but of late there's been improvement in availing of the files because we've created a group where we have the police, the police bosses around here, And I know most of you, if not all of you, are in that group with the DPP where we do our communication. So far we've improved with the police files missing. And going forward, we have the Wadilif system where we enter all our documents into the e-filing system of the DPP. And right now we are scanning the charge sheets to the e-filing. Also, for police files will be scanned going forward, will be scanned, and then we'll be retaining the copies in our e-filing. So, issue of police files missing will be a thing of the past going forward.
I never were a judge during the time when we had police prosecutors. Of course, I interacted with a few. I was involved with some instances when I was in private practice. But of course, I became a judge when it was 100% the lawyers as the DPP. My PJ has been in judiciary longer. He has seen both sides. If there was time, he would have maybe given his perspective. But speaking for myself, I can say yes, I find it the jurisprudence that is coming in from even our judgments has really improved, and it's because of what the trained lawyers bring before us also. They are kind of arguments they bring before us. So if you ask me, the DPP has really improved the kind of submissions. They are able to cut out waste of time, because there are some things that are irrelevant, but they can very easily know what to get out. When they have a list of potential 30 witnesses, they can look at the whole list, see what these people are coming to say. They can reduce them to 5. But somebody who has no proper legal background may not see it that way. So yes, it makes it easier for everybody, and I think the standards have obviously gone up. But if there was a minute you could give Judge Nyakundi to give up today, because he was there in both dispensations.
Thank you, my lord.
When the police were doing the prosecution and when now is the judicial officer, so that we know that as police officer we are not lawyers. We might have been having challenges on maybe interpreting some of the laws, but now with the OTPP coming in, the best possible to get the difference between the two arms when the police were handling matters and when the OTPP is handling matters is the judicial officer. But I think the police during their period, they did their best and they prosecuted cases to their capacity and ability by them.
There's been a conclusion of cases. If you look at cases which have been concluded in 2023, you look at 2022 as you compare with before 2010, you will see that many cases are being concluded currently than it were in 2010. Yeah, maybe I don't have the data right now, but if we can get that data, it can prove my point. Pre-2010 cases were few. Post-2010 cases have been many, and then there's been also conclusion of cases. You've also been told about cases concluded through plea bargaining and diversion, quite a number. So it has helped, yeah.
See, we are not pointing accusing fingers. A court is not a building, a court is a human being. DPP is a human being. The IPOA officer is a human being. Probably he has his challenges and probably is not on duty. Probably him as an IO has not been able to bring the file to court. So we consider some of these delays as occurring for those reasons, and there are many reasons. One other major reason that makes us probably conclude that now justice has been delayed is insufficiency or not having enough staff to dispose of cases. What am I saying? In Eldoret, we have, in the High Court, presently we have 2 judges. Honorable Justice Wananda, Honorable Justice Nyakundi, and our dear judge from Kitale. I do not know whether he has a second judge in the High Court. These are some of the instances that cause delays. I do not expect Honorable Justice Murima in Kitale to handle the entire Trans Nzoia County in matters High Court and criminal. He cannot manage them alone. Adjournments are bound to occur.
For determination, then the offended person may feel that justice has been delayed. Otherwise, from the National Police Service, we normally endeavor to ensure that action is taken within the shortest time possible. Thank you. From the police perspective, justice is said to be delayed. Normally, when any member of the public is offended, they make reports to the police station. So when action is not taken immediately at the time of report, that person may feel that his justice has been delayed. After the report, normally action must be taken. The delay in response will also occasion that delay in justice. Then the third one is after investigations. If the matter...
One, people don't